Divorce does not make underemployment invisible. When someone earns less after a divorce case is filed, the court does not have to accept that lower number just because it appears on a paycheck. That is one of the practical lessons from Jenkins versus Jenkins, a recent Utah Court of Appeals decision involving imputed income, voluntary underemployment, marital fault, and alimony. In that case, the husband had worked for years as an automobile mechanic. Before the divorce was filed, his annual income was roughly $142,000 to $150,000. After the divorce was filed, his income dropped to roughly $96,000 to $101,000. That is a substantial decrease. The husband argued the reduction was not voluntary. He said his employer had changed ownership and that the new business model reduced his compensation. The trial court did not reject that explanation entirely. It accepted that part of the drop may have been outside of his control, but part is not all. The wife testified that the husband had threatened to work less so she would not receive alimony. The court believed her. That mattered. A lower paycheck is evidence, but it is not magic. Courts look at timing. They look at credibility. They look at work history. They look at what the person earned before. They look at whether the explanation for the reduction makes sense. In Jenkins, the court chose a middle ground. It did not use the husband's lowest current income. It did not simply accept the wife's highest number either. It imputed income based on the evidence. That is how many real divorce cases work. They are not always an all or nothing proposition. Sometimes the court says, in effect, I believe part of what you are saying, but not enough to let you off the hook. Jenkins also shows that fault can matter in alimony. Not as revenge. Alimony is not a punishment with a spreadsheet, but Utah courts may consider fault when equity requires it. The broader lesson is this: financial declarations are not holy writ. A paycheck is not always the whole story. A claimed expense is not automatically reasonable just because someone typed it into a form. Divorce courts can ask harder questions. Why did the income drop? Is the explanation credible? What did this person earn before? What is he or she capable of earning now? Would accepting the lower number create an unfair result? Divorce does not make underemployment invisible. It does not make suspicious timing irrelevant, and it does not require a court to accept financial claims that would produce an inequitable result.